Welcome, ladies and gentlemen. My name is Brant Lapish, and I am the VP of Marketing for ESS. I would like to introduce Mr. Todd Higey, General Counsel for ESS. ESS is also known as Employment Screening Services. We provide comprehensive background screening, drug testing, and occupational health services and credentialing solutions to companies throughout the nation. In addition to Todd's general duties as a lawyer for ESS, he publishes academic articles and speaks at seminars on matters pertaining to the intersection of background screening and employment law. Thanks to Todd and the rest of the ESS team, our customers are always able to stay aware of current trends and issues in the fields of consumer reporting and compliance in the employment law. We believe in providing this type of service to our clients to help them navigate the risk associated with hiring in today's market. Todd has been practicing law for nearly 20 years. Before joining ESS, he was a partner in a law firm, trying cases in state and federal courts. He represented a wide range of employers, from Fortune 500 companies to local and closely held organizations. He litigated a variety of employment-related cases such as Title VII discrimination claims, enforcing non-compete contracts and trade law secrets, and defending federal employers' liability acts and lawsuits. Before this, he advised businesses on contract formation, human resource policies, and general risk management. Todd is an avid mountain bike rider and truly an expert in his field. We are privileged to have him on our team here at ESS. Ladies and gentlemen, I will turn it over to Mr. Todd Higey to take over the rest of the webinar.
Thank you, Brant. I appreciate that introduction. And welcome, ladies and gentlemen, to this afternoon's webinar. Does their past impact your future? The EEOC's view of using criminal history in the hiring process. So what do we mean by the question, does their past impact your future? Well, they, when I use that word, refers to applicants for employment who have been previously convicted of a crime. You, of course, is you, the employer, who is considering hiring that applicant for a job. Of course, it impacts your future if you hire an applicant who has a prior conviction and they come to work with you. Because if that applicant whom you've hired commits another crime, then you will be in a situation where you will have to respond to the harm caused by that applicant. But let's step back a second. You might not hire applicants who have criminal convictions, and thus you can avoid them impacting your future. So what is the purpose of this webinar? The purpose of this webinar is to explore the concern and the issue over whether you as an employer are required to hire someone who has been convicted of a crime. In other words, the scenario is this. Someone applies for a job. That individual is qualified for the job. They have the experience and the education required. They may even have work history required. And in all other respects, they would appear to be a good candidate, except they have a criminal conviction. Are you required to hire that individual anyway? That's what we are going to explore here today. Whether you have control of when and how an applicant's criminal history impacts your business's future. Let's step back a second, though, and take a look at why it's important to consider an applicant's criminal history. We have here a statistic that's been published by the Federal Bureau of Justice Statistics. And what this statistic shows is a survey of individuals from 30 states beginning in the year 2005 and running until the year 2010 who had been convicted and released from prison, and the survey examined what was the likelihood that that individual would be rearrested and perhaps ultimately returned to prison. And as you can see, within 5 years, nearly 80% of the individuals who had a previous conviction were rearrested. Nearly 60% were convicted and returned to prison. So, if you hire an individual who has had a criminal conviction, in light of this particular statistic, you may be in a situation where that individual may in fact commit another crime, be arrested, and be convicted. Let's break that down even further. So here's a survey that was done by a professor at Carnegie Mellon University, Professor Alfred Blumstein. He took a look at arrest data from the year 1980 in the state of New York. He looked at 88,000 individuals who had been arrested that year. And he wanted to take a look at crimes that were not completely fatal, such as a homicide crime, no pun intended, and which thus that individual would perhaps have a very hard time finding a job. And he didn't want to look at very low-level crimes like disorderly conduct or even a DUI, where an employer may be more likely to employ that individual and the harm that they might cause if they committed another crime might be minimal. So he picked a sweet spot in between and looked at those who had been arrested and convicted of robbery, burglary, and aggravated assault. And he examined what was the likelihood that those individuals were rearrested for either the same or another crime. Looking at this chart here, go all the way over to the second column from the right at the bottom. You see that statistic there, 14.4%? What that statistic is indicating is out of the total number of those individuals, which was 5,226, only 14.4% were not rearrested. Put differently, nearly 86% of those people who have been arrested and convicted of one of those three crimes were eventually rearrested. And the professor breaks down the types of offenses that those individuals committed that led to their second conviction. So you can see, for example, those who committed robbery were most likely to commit another robbery for their second offense. For a burglary crime, you can see that, again, they are most likely to commit another burglary-related offense for their second offense. But some will commit a violent crime like a robbery. They may engage in other violent offenses or even a property offense. So here, this gives you a tangible picture of what you might expect from a big picture statistical perspective as to what an applicant might be more likely to do than the general population or the population of those who have never been arrested. And of course, the ultimate reason why you're considering an applicant's criminal history is out of a concern for what happens if that individual, now your employee, causes harm. And if that person causes harm to a third person. So, for example, you hire someone to work in a daycare. And they have a prior violent or even predatory offense. You hire that individual, and they reoffend and commit yet another offense against a vulnerable child, then you might expect that the child, by and through the parents, will pursue relief from you as the employer. According to Zurich Insurance Company, the average settlement for negligent hiring is $1 million. This was data published in 2010. Actual verdicts can be higher, quite a bit higher than that, and in some situations they may be lower than that, but this gives you a flavor for the level of exposure. So, of course, going back to the initial slide, you may ask yourself, well, why would I ever run the risk of hiring an individual with a criminal history when I have this kind of exposure and I could just as easily move on to the next candidate who has no criminal history whatsoever? And that brings us to this basic question. Is it lawful to consider an applicant's criminal history? Is it legal for me to look at whether someone's been convicted and say, I'm not going to hire you because you've had a crime? Here is the basic principle that applies really all over the country, in all 50 states. It's a guiding principle that you can look at and consider before you proceed to answer the question in detail. Whatever is not forbidden is permitted. The idea here is, in the absence of a law telling you you can't do something, then generally you can do it. So how does that apply in the employment context? Broadly speaking, employment is at will. You can hire and fire for any reason, or for no reason at all. You could choose not to hire someone because they wear polka dots or they wear stripes, and you just don't want to hire those sorts of people. As silly as that sounds, and it may be a stupid reason for not hiring an individual, it's not an illegal reason, because as long as it's not forbidden, it's generally permitted. This would include criminal history. At a baseline level, it's okay to consider criminal history. It's not illegal. But, and here's the reason for the webinar, there are exceptions to that basic principle. States, for example, have laws on the books. New York and Wisconsin in particular, and now, as we will discuss in a moment, more recently California, have laws which say you can't just simply refuse to hire someone because they have a criminal record. If they're otherwise qualified for the job and they have a criminal record, say these two states, you need to go through several steps to before you come to your decision not to hire the individual. Also, many of you have heard of these fair chance hiring laws, these ban the box laws. When you think about it, these laws, which basically say that before you ask about a person's criminal history, you need to let them apply for a job. In some instances, you need to let them interview for a job. And in a few jurisdictions, you need to go so far as to give an offer of employment, a conditional offer of employment, before asking about or investigating criminal history. These laws would not exist if it weren't the case that it's generally permissible to give consideration to criminal history. And so as of today, I believe there are 10 states out there, there are 8 states out there, Illinois, Connecticut, Minnesota, Massachusetts, New Jersey, Hawaii, and California, which ban the box statewide, or they have this fair chance hiring process statewide. Setting these aside, we come now to the federal law, which is going to be the subject of the remainder of our presentation. Title VII, which is a part of the 1964 Civil Rights Act, which declares that certain employment practices are illegal. So let's look at what Title VII says in essence. It's an unlawful employment practice for you as an employer to fail or refuse to hire someone because of their race, color, religion, sex, or national origin. Additionally, it's unlawful to limit or segregate or classify your applicants for employment in any way which would deprive that person of employment opportunities. And pay attention to that phrase, employment opportunities. It's an important phrase, because of that person's membership in a class. And again, the key classes here for our consideration are going to be race, sex, and national origin. So that is a limitation on the at-will doctrine. The at-will doctrine says I can hire and fire for any reason. Here's a federal law applying in all 50 states, applying to the vast majority of employers, unless you're a really small employer, that says you can't refuse to hire someone because of their race or sex or national origin. And you can't classify them in a way that would deny them or deprive them of an employment opportunity because of their race or sex or national origin. So let's take a look at some actual examples supplied by the Equal Employment Opportunity Commission. As you may know, the EEOC is the federal agency that's been given charge of the task of enforcing laws like Title VII. And so the EEOC has provided its opinion and its guidance on examples of where you would be discriminating on the basis of a protected class in the background checking context, in the criminal history context. Let's take a look at this here. You've got John, who is a Caucasian or a white individual, and you have Robert, who is black or African American. If you look there in the center, both John and Robert have the same education, skills, and work history. And both of them applied for a job at Office Jobs, Inc. Now, both of these individuals have been caught and convicted while in high school of possession and distribution of marijuana. The hiring manager in this instance looked at that conviction, looked at the education, skills, and work history, and with regard to John, who was Caucasian, said, he was a youthful offender and we've had no other conduct. We're going to bring him in for another interview and give him a chance at the job. By contrast, with regard to Robert, the hiring manager actually told a colleague, we really don't need those drug dealer types around here. Well, the EEOC says, look, this is a motive that's rooted in an illegal stereotype. You're just assuming that because he's African American, he's a drug dealer type, and you've basically admitted that by what you said to your colleague. This is an indication of an illicit motive, of an intent to discriminate because of someone's membership in a race. Let's look at another example provided by the EEOC. We have Nelson, who is Latino, and we have Ted, who is white or Caucasian. Both did well in high school with a 4.0 GPA, and they took college prep courses. Over the summer, Nelson worked full-time at a landscaping company, 40 hours a week with a bona fide established business. Ted, by contrast, only worked part-time mowing lawns for the neighbors in the neighborhood using his dad's push mower, and he served as a camp counselor at the local camp. Now, Nelson, while he was in high school, participated in a little bit of a hijinks here. He engaged in some breaking and entering in the school cafeteria. He and his buddies got caught, and they were convicted of a misdemeanor breaking and entering. Ted, he hacked into the computer system for the school and actually changed some grades for some friends of his. He was caught and convicted of a felony. The hiring manager, looking at Nelson, said, we're going to send out a rejection notice. This fellow only appears to be qualified for manual labor, and he's got a criminal record. But Ted, they gave him a second interview. The EEOC says, look, Ted's crime involved untrustworthiness. Nelson's crime did not. And you're stereotyping Nelson as someone only qualified to do manual labor when, ironically, he has a better work history than Ted does in terms of experience actually working at a business, reporting from 8 to 5, so on and so forth. And so the EEOC says, look, this is evidence of an illicit motive, of an intent to discriminate on the basis of someone's national origin. Now, many employers have no intent whatsoever to discriminate on the basis of race, national origin, or sex. They want to be equal employment opportunity. They're genuine about it, and they don't mean to discriminate. The question arises, however, as to whether the employer might, so to speak, inadvertently discriminate by using a policy that is, on its face, neutral. Let me give you an example. You might have an employer that has some sort of skills and abilities test that is applied to every applicant or perhaps it's applied to every employee who wants a promotion, and everyone has to take it. But that practice, that skills test, that ability test may still violate Title VII if it has a disproportionate impact or a disparate impact or an uneven impact on a protected class. And again, these are our protected classes. This is actually now, as of 1991, not only something articulated by our United States Supreme Court, but affirmed by the United States Congress. If you have a policy that's otherwise neutral on its face, but it has a disparate impact, you may still be violating Title VII. And here's where we get to this question about criminal records. If I have a policy that says I will never hire someone with criminal conviction, am I going to have a disproportionate impact? And if I do, have I violated Title VII? How is disparate impact demonstrated? Well, it could be demonstrated by biased statements, sort of like what we already looked at, where the hiring manager or the decision maker actually says something that's indicative of an intent to distinguish between people in protected classes. Inconsistencies in how the hiring decision is made could indicate evidence of disparate impact. What we call similarly situated comparators, perhaps looking at a similar business in the same geographic location, how they do their hiring and what criteria are important to them. But really, the primary evidence in this area is going to be statistical evidence. And when it comes to looking at statistical evidence, you can look at three different types of statistical evidence. You can look at whether the class as a whole is excluded at a substantially higher rate. So, for example, if you have an abilities test, a skills and abilities test, and 90% of the female applicants pass the test, but only 40% of the male applicants pass the test, well, you've obviously got an exclusion at a substantially higher rate. You could look at the percentage of applicants actually excluded, and that's the example I just gave. So you can look at either what happens to your applicants who take the test, or you could look at a comparison to the level of employment of the class to the general local population. So if my local population is 50% men and 50% women, but I'm only employing 10% women as a result of this test I'm administering, well then that statistic may be indicative of a disparate or uneven impact. So, how does this apply to criminal records? Here is a statistic published by the Sentencing Project, which is an initiative advanced by several federal agencies, and they have pulled statistics from the Bureau of Justice Statistics. So this comes from the United States federal government, and you can see right here that if you're looking at imprisonment resulting from convictions, at a nationwide level, you have an uneven impact. For example, 1 out of 9 men are likely to be imprisoned, and only 1 out of 56 women are likely to be imprisoned. So if you have a policy that says, I'm not going to hire anyone who is convicted of a crime and sent to prison, you will more likely than not affect men with that policy more than you will affect women. That same situation applies at the racial level too. 1 out of 17 Caucasian men versus 1 out of 3 African Americans, or 1 out of 6 Latino men. So, given these statistics, what have the courts said? Can an employer refuse to hire an individual who has a conviction? Let's take a look at this case, Green v. Missouri Pacific Railroad. So the railroad had an absolute ban, no convictions whatsoever, and it applies equally to all races. The railroad actually offered a fair number of reasons for having this policy. For example, it was worried about cargo theft. We don't want someone to steal our customers' cargo. This individual may handle company funds. We don't want them to misappropriate the company's money. Bonding qualifications. Is a person able to be bonded in connection with the handling of freight? What if this individual has to testify on behalf of the company, which happens from time to time when you think about it, if there's disputes, labor disputes, or disputes about shipment and delivery of freight. And if this person is a convict, then they might be impeached, and that'll harm the company's ability to defend itself in a freight dispute. Of course, there's third-party liability. If the individual happens to be violent and they injure a customer, why, that customer is going to sue the railroad. And if the individual has been convicted, and as we saw before, there's an nearly 80% likelihood in the immediate 5 years that follows that the individual is going to be rearrested, well, that's going to be disruptive to my work. And it's going to affect my operations. And I'm going to have to find someone to come in and do that individual's job. And, the railroad said, there's an indication of a lack of moral character, and we don't want those employees working for us. So those were the reasons offered by the railroad as to why it didn't matter what your conviction was, you were not going to be able to work for the railroad. So an individual, Mr. Green, apparently opposed the Vietnam War and was a draft dodger and was convicted of refusing to register for the draft. And then years later, he applies for a job with Missouri Pacific, and because he had that conviction, he was disqualified, and he sued the railroad. The court, in looking at this, said, let's take a look at statistics. And so it looked at local data. It noted that in the area where the hiring took place, I believe it was St. Louis, blacks were 2 to 7 times more likely to be convicted than whites. The conviction rate was ranging from 37 to 78%. By contrast, for whites, it was roughly 12 to 17%. The court went further and looked at the actual Missouri Pacific applicant data. It noted that out of 3,200 black applicants, 174 were rejected, which was a 5.3% disqualification rate. Whites, 5,200 applied, and 118 were rejected, which was a DQ rate of 2.23%. So less than half of the disqualification rate. And the court, looking at this, said this policy has a disparate impact, and it is therefore going to be considered and was declared to be a violation of Title VII because you had this across-the-board policy, no matter how old the conviction, no matter what kind of conviction, the individual was barred from employment, and this had an uneven impact right there in that specific geographic location in St. Louis as between blacks and whites. Now I'm going to come back to what the court told Missouri Pacific to do when it came to considering criminal records. But before we do that, let's take a look at broadly speaking, what an employer does to respond to the statistical evidence. Well, you respond with statistical evidence of your own. And previously, we looked at nationwide imprisonment rates. Well, that can vary dramatically, from location to location and jurisdiction to jurisdiction. And so you're not going to necessarily, as an employer, want to look at the national rates, but you're going to want to point out, hey, this is where I do my hiring, and these are the people who are impacted, and these are the actual local rates. You can look at your own applicant data. You can even take a look at and offer evidence of your reputation in the community. Are you known to be an equal employment opportunity employer? Are you known to be colorblind and gender blind in your hiring? So this is the sort of evidence that could be offered to rebut this. But there's a key thing to note. A bottom line result does not save a policy that has a disparate impact on the opportunity to get hired. What is bottom line? Bottom line is the idea that if in my local population group I have 50% men and 50% women, and in my workforce I have 50% men and 50% women, I've got that bottom line correspondence with the labor pool that's relevant for me, therefore I've got no disparate impact. And the reality is the courts say, no, what you look at is not just the bottom line, but also the employment opportunity. This is illustrated by a case involving the state of Connecticut that used a written exam administered to individuals who were wanting to be promoted. The pass rate for this exam was quite a bit, had quite a bit of difference between races. 54% blacks passed, 79% whites passed. So if you go by the pass rate alone and you promote based upon that pass rate, you're going to have an uneven result. So the state of Connecticut decided to use a different promotion rate, essentially an internal affirmative action program where it promoted 23% of the blacks who had passed, and it only promoted 14% of the whites who had passed. And the court said, no, that's not good enough, because this pass-fail barrier denied an employment opportunity to a disproportionately large number of minorities, in this instance to blacks, and it prevented them from proceeding to the next step in the selection process. So unless you can show what we call, and I'll talk about this in a little bit, job relatedness and business necessity, a bottom line defense, racial balance, gender balance in your workforce alone doesn't necessarily address the impact of using a policy, like, for example, a policy regarding criminal convictions. Now, if you do have a policy that does have an uneven impact or a disparate impact, it may still pass legal muster if you have business necessity. The court has said a policy may discriminate against applicants with criminal history if the dangers associated with the specific criminal conduct have been effectively linked to the risks inherent in the duties of the particular position. Well, how do you effectively link? And this goes to the guidance offered by the Equal Employment Opportunity Commission. Many of you may have heard of the EEOC guidance on using arrest and conviction history in the employment context. It was published in 2012, and this is what the EEOC says. You can effectively link if you use empirical evidence, and they refer to the Uniform Guidelines on Employee Selection Procedures. These are guidelines that are published by the EEOC in conjunction with the Department of Labor and the Department of Justice. And really, in a nutshell, what they're looking at there is if you're going to have a bright line policy, you're going to have some scientific evidence, and usually in the form of statistics, that justify your policy. A bright line policy is one that applies across the board. There's no discretion. If you've been convicted of robbery, you can't come work for our business. That's a bright line policy. It doesn't matter who you are. It doesn't matter what the circumstances were. It doesn't matter how long ago it was. You can't come work for us. If you can't do a bright line policy, if you can't offer the scientific evidence needed to prove and justify your bright line policy, then you could do a targeted screen with an individualized assessment. Let's look at the bright line policy first. It's got to distinguish between the applicants that do and don't pose an unacceptable level of risk. So the evidence you offer has got to actually show that there really is a risk and that it's going to be an unacceptable risk. And of course, as you would expect, this is done through statistics. Let's take a look at some statistics. This is a chart that was published by the fellow I mentioned before, Professor Blumstein. And it's an interesting chart. It relates to individuals from the state of New York who were arrested at age 16 for burglary. And how long do you have to go arrest-free before your likelihood of arrest is close to the never arrested population? So the never arrested is the person that, as it sounds like, has never been arrested during their life. All right? You can see that you almost have to get to 14 to 15 years before you get within spitting distance, so to speak, 0.03% 3%, 0.03 of the never arrested. But what you notice is you will never ever get to the level, the baseline level of never arrested, meaning if you hire someone who was previously arrested and convicted, they will always, no matter how long ago it was, have a slightly higher likelihood of being rearrested than an individual who has never ever been arrested. This is the sort of data that an employer could look at and begin to formulate, all right, if I'm going to hire someone with a conviction, how long do I wait before I get to the point that I can hire them, knowing that the risk is so low that it's reasonable to hire that individual? Here's another one from the same professor for robbery that was committed at age 18. And again, you're getting out to about 14 years before you get to something relatively close to the never arrested, the 3% likelihood. But as we all know with statistics, you can look at it many different ways, and here's another way of looking at the situation. We've been looking at the never arrested, but there are also the general population. These are individuals who do include people who will be arrested at some point for one thing or another. And if you want to look at how long does a person have to be arrest-free before their likelihood of rearrest hits the general population, well, that's actually a shorter period of time. For burglary, it's 3.8 years for this population group out of New York. For aggravated assault, it's 4.3 years, and for robbery, it's 7.7 years. So if that was the crime that was committed and you want to get to the baseline of the general population, then your window is narrower or tighter. So, for example, let's look at a scenario offered by the EEOC on the subject of bright lines. Let's take a bank. It says we're not going to employ anyone if they've been convicted of a financial or fraud crime in the last 20 years. Just an absolute across-the-board policy. Now, federal law only requires banks not to hire people who've been convicted for a period of 10 years. Suppose we have Sam, who is a Latino, and he was convicted of a misdemeanor misrepresentation of income on a loan application 15 years ago. Bank says, we're not going to hire you. The EEOC says, hey, being crime-free for 10 years indicates you've got no evidence of an elevated likelihood of financial crimes. Of course, you may be saying to yourself, wait a minute, I just looked at statistics a slide or two ago that said the opposite, and you would be correct in your observation. The EEOC was apparently not looking at those statistics published by Professor Blumstein when it made this statement. It does bring home the point, though, that the EEOC wants to look at how long the person has been arrest-free or conviction-free after the initial conviction when it comes to crafting your bright line policies. Here's a really good chart. This one was published by Professor Blumstein, and I believe it ultimately came out after the EEOC's 2012 guidance. You can see it was published toward the end of the same year. This is an interesting chart. C1 indicates the first type of crime. C2 there on the left indicates the second type of crime. The letter A indicates the age at which the first crime was committed. 0.01 is a 1 chance out of 100 that an offender will be rearrested. So let's suppose an employer says, I can tolerate 1 chance out of 100. How long do I have to wait after the person was convicted of a crime before I can conclude that the person is only 1 out of 100 times likely to reoffend? Well, it actually varies depending upon the initial crime and the subsequent crime. So in the bank context, let's look at property there on the bottom. If the initial crime was a property-related crime, credit card fraud or something, or misrepresentation of income in order to get something, depending on the age of the individual, 9 to 12.5 years will have to pass before the likelihood of recommission of another property-related crime gets down to 1 out of 100. You can do the same thing. I mean, look at violent. If violent the first time, violent the second time, you're looking at waiting 14 to 15 years before you get to that 1 out of 100. And if you want to look at the subject of getting to the point of something relatively close to the never arrested, and again, general population includes people who got arrested at other and different times. The never arrested are those who have never been arrested. You can see here on the far right side that for a violent crime, you're going to have to wait 11 to 15 years before that likelihood of reoffense drops to the point at which it's something like the never arrested. Drugs and then property. You can see those stats there too. This data, incidentally, unlike the earlier data, was drawn from 3 different states, Florida, Illinois, and New York, over a period of years. And so he was attempting, this professor was, to get a broader sampling to see if other states, if the data in other states was similar to what he was seeing in New York. And really the upshot was is there is variation between states, which highlights the importance of looking at your local data to the extent you can do so. So let's say you're not finding the data that you need to establish a bright line policy, or you would prefer to go the route of a targeted screen. The Missouri Pacific Railroad case, that court said, well, if you want to consider these factors, we will allow you to exclude an individual on the basis of prior criminal history, even if it has a disparate impact. So you're going to look at the nature and gravity of the crime in contrast to the nature of the job. So, for example, if someone was convicted of theft and they convicted theft, let's say it was by worthless check, and you're going to hire them to be a bookkeeper and have access to your checkbook to write checks to vendors, to pay the vendors, well, that would, at a common sense level, seem to be a type of crime that relates to the nature of the job. Time elapsed since the offense, the EEOC actually doesn't discuss this factor in terms of the statistical data we were looking at, but that would be very relevant data. So let's look at some examples offered by the EEOC. National Equipment Rental Company has an internet job application, and if you answer yes to a crime on that application, it automatically terminates. There's no record of why that policy was adopted. There's no information about why convictions, any convictions, pose an unacceptable risk for every single job at that company. The EEOC says, look, you haven't shown that that's job-related or consistent with business necessity. Let's look at another one. We have an applicant. Well, in this case, he's actually an employee. His name is Leo, and he's African-American. And he's been an account executive at an ad agency for 3 years. A change of ownership occurs. And the new owners, they want to conduct a background check, and they're not going to tolerate anyone with a conviction. They say, hey, look, we need the best of the best for our company. And a quality workforce is a key driver of profitability. Now, 20 years ago, Leo was convicted of a misdemeanor assault. Since then, of course, he went to college, he's had successful employment, and his reviews were rave reviews. Nonetheless, the new company, the new ownership, terminated his employment. The EEOC said, look, there's no business necessity because there's no evidence that any conviction of any type poses a risk for all jobs, and there's no evidence that any conviction poses poor work or lack of professionalism risk. And of course, what really weighed in Leo's favor is the fact that he's been already working at this ad agency for 3 years without incident and with good reviews, and he's had successful efforts since then, having gone to college and being gainfully employed. Once you've conducted this targeted screen, the EEOC says, look, the analysis is not over yet. You now need to conduct an individualized assessment. Incidentally, those fair chance hiring laws that I mentioned earlier in our seminar, the more robust ones require the targeted screen and the individualized assessment. They're actually basically saying, look, the EEOC says that this is how they interpret Title VII, this is how they're going to enforce it, but we here, for example, in Los Angeles County or in the state of California or in the city of Austin or in the city of New York, we're going to require employers to do this. And so you're going to have to look at mitigation evidence. What were the circumstances surrounding the offense? Was the individual the primary perpetrator? Did he get caught up in a bad group of individuals? Was he really young and it was really a youthful indiscretion? What about rehabilitation evidence? Has there been education since then? Maybe the individual went to therapy. Maybe the individual gave back to the community and volunteered in some fashion that would speak positively about him or her. Have they only been convicted once, or do they have a series of offenses? The age at the time of conviction, again, were they young, meaning it was an indiscretion, or were they released from prison later in life? And there are statistics showing that if you've been released from prison later in life, you are probably less likely to reoffend just because you have gotten older and longer in the tooth. Have they done the same type of work already post-conviction, and have they done it successfully and without incident? And more broadly speaking, what sort of employment history have they had? And can they offer suitable character references? So you're going to do the targeted screen with the individualized assessment in order to justify a policy which will have an uneven or disparate impact. So let's take a look at an example offered by the EEOC. A county community center has a targeted screen. You can't work in a position with access to personal information if you've had a theft conviction in the last 4 years. When they crafted their policy, they took a look at local county corrections department data, national criminal data, and recidivism research for theft crimes, kind of like what we looked at earlier in this webinar. And the policy even says, look, we'll give you an opportunity to apply for an exception. You have Isaac, who's an Hispanic. He applied to be an admin assistant with unsupervised access to credit card info and personal property. And he was convicted of credit card fraud 20 months ago, so within the 4 years. He was DQ'd. He provided references and asked for a second chance, but the county community center said no. The EEOC said this is justified. It's a policy that's carefully tailored to assess the unacceptable risk in relevant positions. Let's look at another example that almost might be counterintuitive. A shredding company employing 100 people to pick up, transport, and shred sensitive documents. Right? So you've got a lot of access to people's personal identifying information, which might facilitate identity theft. Let's say shredding company sold to another company called New Shred LLC, and New Shred was going to do a bright line policy saying, no employee with our company if you've been convicted of theft or fraud in the last 5 years. So it's somewhat tailored, right? It's not looking at all convictions, but this specific type. You have Jamie, who's an African American, but he's already worked for shredding company for 5 years, and his performance appraisals show he's reliable, trustworthy, and honest. He was convicted of misdemeanor insurance fraud 5 years ago because he exaggerated the cost of home repairs after a storm, and he was terminated. The EEOC, in its opinion, feels like this termination is not justified because of his prior history of trustworthiness. And the EEOC felt the claim that he posed an elevated risk of dishonesty was not supported factually. Now, in the scenario offered by the EEOC, they did not deal with or address some of the statistical evidence that you and I looked at earlier in this webinar. And that evidence may actually change the outcome of this situation. I will say this. The EEOC has had not a lot of success, and neither have individual employees or applicants had much success in persuading courts that a criminal conviction exclusion policy doesn't satisfy business necessity. As a matter of fact, there's been some difficulty even in proving disparate impact. So the reality on the ground is most employer policies that relate to criminal convictions and exclude based upon criminal convictions have survived challenges. That being said, if you're going to craft your own policy, you may want to go through something like this flow chart. The threshold question is disparate impact. If the answer is no, then you're done. You don't have to do anything further with regard to this otherwise neutral policy. If it does have a disparate impact against someone based on their sex or race or national origin, then you're going to want to identify the risks associated with each job that you have. Threats to people, threats to property, illegal drug use, threats to job performance. Identify for each job the threats that are present. And then the next step is identify those crimes that are associated with those risks or those threats. And I provided some examples of those crimes for you. After that, you're going to want to look at your recidivism data. You're going to want to use some of the data that we looked at. There are other criminologists that have published data on this issue. And then, of course, you've got broad national data published by the Bureau of Justice about the fact that, you got to wait at least 5 to 7 years before that rearrest rate really starts to drop. If you've got a lot of strong statistical evidence, you can use a bright line policy. If you don't feel you have that sort of evidence and you'd rather use what we would call a common sense approach to the situation, then you're going to need to conduct an individualized assessment like what we laid out. Now, I want to leave you with a word on the EEOC's enforcement guidance. It's not the law. The law is Title VII, as interpreted by the courts. A court might choose to disregard the EEOC guidance, and indeed some courts have disregarded the EEOC's guidance on this subject. It doesn't mean, though, that you want to ignore it, because it does indicate enforcement policy. And so if you ignore it, you do so at your peril. The EEOC went after BMW a few years ago on this exact issue. It's currently litigating a case against Dollar General. BMW settled its case. The Dollar General case is still pending. The EEOC in the past has sued schools who gave consideration to credit history and employers who gave consideration, to criminal history and credit history. And in those particular suits, the court actually dismissed them because the EEOC had not even proven that there was disparate impact. So you may decide that, hey, we don't think this enforcement of guidance applies to us, or we don't think it's a correct application of the law. I would caution you, of course, to do so in consultation with your legal counsel before you take the step of deviating from what the EEOC recommends in its enforcement guidance. In a broad sense, hiring policies ultimately concern the management of risk. The courts recognize this. It is okay to manage risk and to have a hiring policy designed to do that. If that policy is discriminatory, it must accurately but not perfectly determine an applicant's ability to perform successfully, in this instance, safely in the job. So the courts don't require a perfect proof. They do require some accuracy, though, if it's a discriminatory policy. And Title VII does not require an employer to accept an unqualified or less qualified candidate. I thank you for your attention this afternoon. I, of course, have my obligatory legal notice, and really the point of this is, as you can tell, this is a complex issue. And it's an issue important to the EEOC and to various cities and counties and states throughout the country. You would be well advised to talk with your employment counsel as you craft or refine your background screening policy. And with that, I believe we have a few minutes for questions. Brant, I'll turn this over to you.
Thanks, Todd. Like Todd said, now we'll take some questions. So there's a question box. If you do have any questions, just type some in there. We have some coming in. I want to mention to everyone to say that if you're interested in keeping up with more industry news or more information similar to this, you can head over to our website at es2.com. That's ES and then number 2.com and sign up for our newsletter. So the first question is, what about, how will you speak to about It says, how about disqualifying people because they failed to disclose convictions on their applications? Will you speak to that?
Absolutely. So going back to the basic principle, this is employment at will, and whatever is not forbidden is permitted. It is perfectly appropriate to disqualify someone for being dishonest with you, because that is essentially what this is. Someone has not told you the truth. And honesty, I dare say, is probably relevant to just about every job that you might employ someone for. The only caveat, the only thing to be aware of, is there are some cities and states in the country which have said that you cannot ask about someone's criminal conviction at the application stage. And so there, you just quite simply can't do it. Now, you can ask them later on during an interview, and if they deny a conviction and then you subsequently discover it, why then, of course, you can take action based upon that dishonesty.
Great. So the next question is, what do you do when you've gotten a targeted screening and are looking into the circumstances so that there's something on the applicant's record and you ask for their explanation? Do you just have to take their word for it? So this attendee said the example is a lot of times they have theft on their record, and it says they usually say that they're with someone else and they actually didn't steal anything. Does she have to take his word for it, or what to do with that, Todd?
You do not have to take an individual's word for it. You are entitled to judge their credibility. And the thing to keep in mind, if you have a true targeted screen with individualized assessment, there are going to be a lot of factors that play into your assessment as the hiring person when it comes to your decision. And so, no, you don't have to take them at your word. You can, by assessing how they behave when they answer the question, their body language, the tone of voice, you're entitled to conclude, I don't think you're telling me the truth. This is no different than what juries are instructed to do every time they judge a case at trial. You're entitled to assess the individual's honesty. You don't have to, so to speak, take their word at it, even if your gut tells you they're not telling you the truth.
Hey guys, that's all we've got time for questions. I see there's a couple more that we can answer directly offline. Thank you again for joining us, and we hope to offer some more great webinars like this with good content. And if you have any questions, you can reach out directly to me at blapish@es2.com, and that's B as in boy, Lapish @es2.com. Thank you so much.